Ati for Oquaye daily update TV na message and na ba channel is on wa hit adoma no subscribe. Se me drop the latest news content bia obeje brain no nya bi etie na ya bora ensem no ma the latest news etie for airport no. Ya na meka se eye easy body way no. Like ye hu wo musu bida. Ohwe afari jan charoto semon no mo mabaye yisi mpanimfo djuma omubedi ya eya koyese jimen sane bosman sare ne is some of the issue officials now atipo ye hu omi because per report yen saga Dome-Kwabenya ijada hukukukuku so chese DC for the team issue officials ni bi omahuno match na ekame say wa fabricate o ma fabricate some of the pink sheet no ampeso mudi ye in favor of MPP Michael Oquaye Jr. no ba omo so omo mpene kwan bia so omo mpene na empene chena omno ne befe so pa na ye mongram yentie ensem ni bi free ho ba no ye ba de ka ho bia no medi munsem bebrem.
I said even pursuant to the court order that's been planned, the court says go and do recollation. Recollation means retabulate. But for so he won't have it. You saw me on the video. He won't have it. Yeah. Court says go and retabulate, go and recollate. You say you won't do recollation. You want to continue from where you left off. So I ask him, where did you leave off? Whatever you claim you had left off, you had petitioned your principals in Accra and said it was a process that was fraught with irregularities. So he actually used the language that it should be annulled. Then they give you the opportunity, then you come and tell me that where we were, those two pensions that we were resisting, those are the pensions you want to add. You are not interested in going back because you see, they had also fabricated some. So the conduct, today I want to speak to conduct of public officers. When you are a public officer, that is just be a public officer. If you want to be partial, if you don't want to be neutral, if you don't want to be a public officer, leave the job. Go and be a party executive and come and do party work. Be a party full soldier. Let everybody know that you're a party full soldier. Or be a farmer like my brother who is and now a businessman. You are a businessman as well. Okay. But to be wearing EC jacket, when it's used them, then they quote the Constitution and says that in the performance of their functions, they are independent. But in your utterances, you are not portraying that independence. You are portraying bias. When you wear EC jacket, that should portray you as a neutral, independent operator. Your comments do not reflect the content of the garb you put on.
So, but why did the trial judge in the High Court, that's the first case when the mandamus was heard last week Friday, yes, why did he not give the NDC a hearing?
That is a question for the gods to answer.
I'm asking you.
You heard the judge, the Supreme Court, the president of the panel, said that to allow Eduji to speak in his capacity as a friend of the court was not coterminous to giving him the opportunity to represent his clients. The two standings were markedly different.
And the trial judge thought that because Eduji had spoken,
and the Supreme Court did something very important. They noted that in the ruling of the court or in the court proceedings brought before them, they noted that the judge actually recorded Eduji as a friend of the court. That was his undoing. That was the judge's undoing in this matter. That was where the Supreme Court nailed him.
And if he's a friend of the court, then
I can also appear as a friend of the court. But he was supposing to him that we are here on merit. We have an application before you.
But I think there was an application for joinder.
Yes. Yes. So the judge indicated that yes, I have been informed.
In the case where there was an application for joinder,
yes,
rightly before the judge, he couldn't have come as an amicus.
Exactly. So that's why the Supreme Court got him.
Judge record him as a friend of the court?
That is what I...
Because, you see, the application before him, that's Gary Maku's applications, his clients were not named as parties.
They came as party. But as being a proactive lawyer When you hear things like that, you can actually, because you see, the notice, when it says something is on notice to you, is to give you notice. So you can take proactive steps. That I hear there's an ex parte application, but indeed, Bega actually said that in matters such as this, even the court, Suomotu, ought to have directed that let the application ex parte be actually served.
An important history fact. Do you remember the 2008 election? MPP went ex parte
on one Sunday.
One Sunday. So the NDC got wind of it and
we went
to the court. Hey, NDC had not gone there. I thought they wanted court on time.
You know, so these are serious matters. Let me
a quick input from
okay. Yes. It is an addition to the court procedure that ought to inform all courts. In matters like this, it is important that the Judge Somoto ought to have made an order for them to come on notice. And it happens most of the time when you see that there is an interest in the case that is not represented in the matter pursuant to the application.
It's only fair.
It wasn't fair. And by law, or the author, that, oh, please, can you come on notice on this one so that the other party will also be heard. If you came as party, then the explanation is that even the EC, who was a defendant in that matter, a respondent in that matter, had not been served. You see, and in fact,
AC said they are not opposed. They were playing along.
They had not been served if it was an ex parte application.
But they indicated that they were not opposed to it.
But if it was an ex parte application, so to speak, then one would say that the EC would not be served in an ex parte application. Nevertheless, the judge ought to have directed that you come on notice. And in any case, Madamu's application will not be ripe until they have been served with written communication that you have reneged on this statutory duty and you are by law required to do, and the public institution fails to respond to your warning. It is then that Madamu's application become ripe. I don't know whether on record all such communication had been shown.
Now, in addition to what Andy had just submitted, you will see that if you look at the application, the exhibits attached to the affidavit in support, you will see letters from these respective applicants. All of them wrote to the EC demanding that they perform this statutory duty.
Right.
Now, let me... so, for instance, Eric Nana Juma Prempe wrote. He wrote, is dated 16th December. 16th December. Now, the question is, when did you send this to the EC, such that the next day you were in court? You understand?
Okay.
Now, Charles Forson didn't date his letter. But he also came to court. So they all came to court the same day. But as to the point Andy made that a formal demand was made on a public officer to perform his duty under law or perform a public duty, and yet he failed. So this Tema Central matter, when we came before the regional coalition, we demanded that the proper thing be done in law. He won't have it. He had come with an agenda. He had come to insist that those two corrupt pinches be added. Then he was to declare. That was his agenda. He was not interested in what the court had done. The same applies to Baba Sadiq in his case, because they only added those 31 and declared. Because you recall some percentage argument that if 60% of the coalition seats have been collated, then it can be declared. But there's no such authority in law. So clearly, I want to make the point that in ex parte Asare, the Supreme Court is very clear, and Justice Ansah made the point that where results have been declared, the appropriate forum for you is to petition. And the law provides petition. The process is the procedure to petition under Section 20 of PNDC Law 284. It tells you what you should do. But under CI 127, when results are declared, however irregular that may be, it's only a court that is pursuant to, you go to the High Court pursuant to Article 99(1), I'm sure, clause A, thereabout. Yeah. That gives you the mandate. So all we are saying is that let the proper thing be done. So for me, the Mandamus application before the court that we are being asked to go and contest, I know what the legal team can do. Right. For me, I will rely on the Supreme Court decision and not even pursue this matter. Why? Because I can say, for instance, that in pursuance of law, the application before the court is incompetent. Because of the Supreme Court ruling? Yes, I can rely on it. Yes, it's incompetent. Yes. Then two, I'll quote the law. I'll quote PNDC law, law 284 for you, section 20, as a preliminary legal point. That pursuant to section 20 of PNDC law 284, this application cannot be entertained. The court has no jurisdiction. I can do that. I see. Well, yes, I can do that.
Supreme Court has directed.
Yes. But I'm saying that as lawyers, lawyers.
But you have a right.
Yes,
but again, the Supreme Court has directed that go back to the instant court, and then.
But let me make the point. Let me finish.
Yes, I think that because of the point you made.
Yeah, but let me finish the point. But I'm saying that alternatively, I'll join properly, like the court said. If it's granted, the joinder too must be heard and granted. And in granting the joinder, it must also be supported by affidavit evidence. I will submit evidence that, contrary to your deposition, that there was, for instance, in paragraph 17 of Charles Force's application, that there was no collation. Collation actually happened and declaration officially made. I will exhibit the video recordings.
I see. Per the Supreme Court direction, we have gone to point 0.
Yes. The status quo ante.
Yeah. So there is technically no application before the court.
Thank you.
So at point 0, I would, if I were part of it, I would advise that file a fresh application, whether it's mandamus or whatever.
I think advice
a fresh application and join the other parties. So that you are.
So technically, you are withdrawing the expertise.
Technically,
that's what has been another issue. That the MPP can just go back and withdraw their application.
By practice, once you file one on notice,
bring the parties to court, and this is on notice, and then they will exercise their right either to respond or not to respond.
Yes, well, I agree.
And in the case that they respond by an affidavit in opposition, then they will depose to the facts as they know them. But I want to advise that at this point, we are only just dealing with the application or no application, whether somebody will reapply or not reapply. And whether the pursuant to the application, somebody will respond or not respond.
Yes.
And leave the matters of determination of content to the court, because it will be on evidence. All that the positions and things, but my only candid and small mind's advice is that when somebody makes a deposition, you may disagree with it, but the outright dismissal of it as not correct or not factual or that one, that authority lies with the court. But you may disagree and prefer a counter position to it and leave the court to make that determination of whether or not there is perjury, whatever. But you can plead to that, and then the court will maybe even address the issue of perjury. But me and you sitting here saying that somebody's deposition is perjurious, I think we should be careful and mindful of how we judge other people, because the judgment doesn't rest with us, it rests with the judge. So,
no, Andy, the point, you see, we are lawyers.
A quick one.
And I have only done what the lawyers do. I have looked at his affidavit. You see, affidavits, they are wittier, because these are depositions on oath. You have deposed on oath that, for instance, there was no collation in Intermacentral. And I'm saying you have perjured yourself, because in your own statement to the EC demanding that they come and perform that statutory duty, you indicated that there was some collation. So how do you now go to court and swear that there was no collation? That's the point I'm making. So I'm saying that even with the content of his own affidavit, he's perjured himself. And I can do that as a lawyer. I can also disagree with the content and say that the matters deposed to are not factually correct.
Yes.
Lawyers, we say that. Yes, they are not accurate.
But
You're not
when
factually
you
correct.
become so judgmental.
Oh, how judgmental have I been?
Okay,
My friend, a businessman.
Okay, so you reveal the identity of the businessman.
The two of you are talking across purpose.
We are not talking across purpose.
He says, I'm a businessman. You say that I know a businessman.
Yeah, but that is a long outstanding matter.
Two positions cannot be the same.
I am referencing your new status as a businessman.
Well,
I want you to reveal the identity of the businessman.
Of the businessman you encountered in the past.
What I'm saying is that you are not speaking the same language.
Okay.
No. We are speaking at different things.
Well, in the end, at least there's an oral team member here, so he has an interest in this. If we don't get to know of it today,
well,
we'll get to know of it tomorrow.
Send me with an application.
No, who sent you the application?
That's fine. But
you do that
people, I want to bring you at this point and this matter of whether there's really a challenge for the NDC to deal with in the coming days, in the effect that these results we're talking about, that the Supreme Court has directed that the status quo to be restored, has been gazetted by the Electoral Commission. The Oquaye Central, Tema Central, Ablekuma North, and then the case of Techiman South. In fact, Techiman South, not Ablekuma North. It's been gazetted.
Yes.
It's part of the 274 that the Electoral Commission has gazetted, and the rate of elections sent to the clerk to Parliament. Now, we understand already some of the MPs have started registering to be part of the entire process of inaugurating this 9th Parliament.
Madam Assessor, someone Daily Update TV.